Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just me again. I'm about to get into the third part of our 3-part release of Andrews and the Law Society of BC. If you want to hear me and Zach chat about the case, head on back to 2 episodes ago. If you want to hear the decision of Justice McIntyre, head to the previous episode. I'm about to read to you the decision of Justice Laforêt. Hope you enjoy. The following are the reasons delivered by Justice Laforêt. This case concerns the application to aliens of the equality provision of the Canadian Charter of Rights and Freedoms, which for convenience of reference I reproduce here. 15.1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. At issue is whether Section 42 of the Barristers and Solicitors Act, by restricting admission to the Bar of British Columbia to Canadian citizens, violates Section 15.1. My colleague, Justice McIntyre, has set forth the facts and the judicial history of this appeal, and it is unnecessary for me to repeat them. Nor need I enter into an extensive examination of the law regarding the meaning of Section 15.1, because insofar as it is relevant to this appeal, I am in substantial agreement with the views of my colleague. I hasten to add that the relevant question as I see it is restricted to whether the impugned provision amounts to discrimination in the sense of which my colleague has defined it, i.e. on the basis of irrelevant personal differences, such as those listed in Section 15 and traditionally in human rights legislation. I am not prepared to accept at this point that the only significance to be attached to the opening words that refer more generally to equality is that the protection afforded by the section is restricted to discrimination through the application of law. It is possible to read Section 15 in this way, and I have no doubt that on any view redress against that kind of discrimination would constitute the bulk of the court's work under the provision. Moreover, from the manner in which it was drafted, I also have no doubt that it was so intended. However, it can reasonably be argued that the opening words, which take up half the section, seem somewhat excessive to accomplish the modest role attributed to them, particularly having regard to the fact that Section 32 already limits the application of the Charter to legislation and governmental activity. It may also be thought to be out of keeping with the broad and generous approach given to other Charter rights, not least of which is Section 7, which, like Section 15, is of a generalized character. In the case of Section 7, it will be remembered, the Court has been at pains to give real meaning to each word of the section so as to ensure that the rights to life, liberty, and security of the person are separate, if closely related rights. That having been said, I am convinced that it was never intended in enacting Section 15 that it become a tool for the wholesale subjection to judicial scrutiny of variegated legislative choices, in no way infringing on values fundamental to a free and democratic society. Like my colleague, I am not prepared to accept that all legislative classifications must be rationally supported before the courts. Much economic and social policy making is simply beyond the institutional competence of the courts. Their role is to protect against incursions on fundamental values, not to second-guess policy decisions. I realize that it is no easy task to distinguish between what is fundamental and what is not, and that in this context, this may demand consideration of abstruse theories of equality. For example, there may well be legislative or governmental differentiation between individuals or groups that is so grossly unfair to an individual or group and so devoid of any rational relationship to a legitimate state purpose as to offend against the principle of equality before and under the law as to merit intervention pursuant to Section 15. For these reasons, I would think it better at this stage of charter development to leave the question open. I am aware that in the United States, where Justice Holmes has referred to the Equal Protection Clause there as the last resort of constitutional arguments, the courts have been extremely reluctant to interfere with legislative judgment. Still, as I stated, there may be cases where it is indeed the last constitutional resort to protect the individual from fundamental unfairness. Assuming there is room under Section 15 for judicial intervention beyond the traditionally established and analogous policies against discrimination discussed by my colleague, it bears repeating that considerations of institutional functions and resources should make courts extremely wary about questioning legislative and governmental choices in such areas. As I have indicated, however, this issue does not arise here, for we are concerned in this case with whether or not the legislation amounts to discrimination of a kind similar to those enumerated in Section 15. It was conceded that the impugned legislation does distinguish the respondents from other persons on the basis of a personal characteristic which shares many similarities with those enumerated in Section 15. The characteristic of citizenship is one typically not within the control of the individual, and in this sense is immutable. Citizenship is, at least temporarily, a characteristic of personhood not alterable by conscious action, and in some cases not alterable except on the basis of unacceptable costs. Moreover, non-citizens are an example without parallel of a group of persons who are relatively powerless politically, and whose interests are likely to be compromised by legislative decisions. History reveals that Canada did not for many years resist the temptation of enacting legislation the animating rationale of which was to limit the number of persons entering into certain employment. Discrimination on the basis of nationality has from early times been an inseparable companion of discrimination on the basis of race and national or ethnic origin, which are listed in Section 15. Professor Ivan L. Head traces the history of this intolerance in Canada from early common law restrictions on inheritance and landowning to more modern developments. Especially germane to this issue are the many instances Professor Head recites of provincial legislation aimed at reducing the opportunities available to aliens in the workplace. Since some impediment to these strategies existed by reason of the federal legislative power over naturalization and aliens, the provinces had recourse to a number of devices to achieve its objectives. Thus, as Head points out at page 128, inclusion on the voters list became a prerequisite for all sorts of economic activity, for admission to professional societies, for obtaining land lodgers' licenses, for obtaining a beer license. Restrictions regarding professions and trades were not limited to the legal profession. They extended to pharmacists, optometrists, bankers, and others. As Professor Head observes, the nation has gained maturity in this area, and legislation aimed at creating closed-door types of labor legislation respecting aliens has tended to disappear. Here there was no allegation that the purpose of the legislation was based on discriminatory considerations. The argument centered rather around the adverse effects of the legislation. There is no real dispute that such adverse effects exist. The trial judge, Justice Taylor, set forth a number of situations, and there are certainly others, where this legislation could detrimentally affect a permanent resident of Canada who has not yet attained citizenship, the group which would normally be affected by the legislation. It can seriously delay them, frequently as they await the period necessary to acquire citizenship, in entering into the profession of their choice, a matter which, of course, may have important long-term implications for their future careers. There is no question that citizenship may, in some circumstances, be properly used as a defining characteristic for certain types of legitimate governmental objectives. I am sensitive to the fact that citizenship is a very special status that not only incorporates rights and duties but serves a highly important symbolic function as a badge of identifying people as members of the Canadian polity. Nonetheless, it is, in general, irrelevant to the legitimate work of government in all but a limited number of areas. By and large, the use in legislation of citizenship as a basis for distinguishing between persons, here for the purpose of conditioning access to the practice of a profession, harbors the potential for undermining the essential or underlying values of a free and democratic society that are embodied in Section 15. Our nation has throughout its history drawn strength from the flow of people to our shores. Decisions unfairly premised on citizenship would be likely to inhibit the sense of those who are discriminated against that Canadian society is not free or democratic as far as they are concerned, and such persons are likely not to have faith in social and political institutions which enhance the participation of individuals and groups in society, or to have confidence that they can freely and without obstruction by the state pursue their and their families' hopes and expectations of vocational and personal development. While it cannot be said that citizenship is a characteristic which bears no relation to the individual's ability to perform or contribute to society, it certainly typically bears an attenuated sense of relevance to these. That is not to say that no legislative conditioning of benefits, for example, on the basis of citizenship is acceptable in the free and democratic society that is Canada, merely that legislation purporting to do so ought to be measured against the touchstone of our Constitution. It requires justification. I turn then to a consideration of the justifiability, fairness, or proportionality of the scheme. I agree with Justice McIntyre that any such justification must be found under Section 1 of the Charter, essentially because, in matters involving infringements of fundamental rights, it is entirely appropriate that this government sustained the constitutionality of its conduct. I am in general agreement with what he has to say about the manner in which legislation must be approached under the latter provision, in particular the need for a proportionality test involving a sensitive balancing of many factors in weighing the legislative objective. If I have any qualifications to make, it is that I prefer to think in terms of a single test for Section 1, but one that is to be applied to vastly differing situations with flexibility and realism inherent in the word reasonable, mandated by the Constitution. The degree to which a free and democratic society such as Canada should tolerate differentiation based on personal characteristics cannot be ascertained by an easy calculus. There will rarely, if ever, be a perfect congruence between means and ends, save where legislation has discriminatory purposes. The matter must, as earlier cases have held, involve a test of proportionality. In cases of this kind, the test must be approached in a flexible manner. The analysis should be functional, focusing on the character of the classification in question, the constitutional and social importance of the interests adversely affected, the relative importance to the individuals affected of the benefit of which they are deprived, and the importance of the state interest. With deference, however, I am unable to agree with Justice McIntyre's application of these principles to the present case. I therefore turn the task of balancing the objective sought to be accomplished by the legislation against the means sought to achieve that objective. On this issue, though she performed the task under Section 15, I largely share the views expressed by Appeal Justice McLaughlin in the Court of Appeal. While there is no evidence on this point, the Attorney General offers 3 purposes sought to be attained by the legislation. These are 1. Citizenship ensures a familiarity with Canadian institutions and customs. 2. Citizenship implies a commitment to Canadian society. 3. Lawyers play a fundamental role in the Canadian system of democratic government and as such should be citizens. With respect to the first touted objective, Appeal Justice McLaughlin, speaking for the Court of Appeal, had this to say, quote, "Citizenship does not ensure familiarity with Canadian institutions and customs. Only citizens who are not natural-born Canadians are required to have resided in Canada for a period of time. Natural-born Canadians may reside in whatever country they wish and still retain their citizenship. In short, citizenship offers no assurance that a person is conscious of the fundamental traditions and rights of our society. The requirement of citizenship is not an effective means of ensuring that the persons admitted to the bar are familiar with this country's institutions and customs." End quote. I agree. As Robert L. Lenoir in his article, Citizenship as a Requirement for the Practice of Law in Ontario, put it, it should not be supposed that any missing necessary tradition will simply be acquired immediately upon receipt of citizenship papers. One can understand the Law Society's argument that while the citizenship requirement does not ensure familiarity with Canada or its laws, there can be no doubt it helps. But such a familiarity really usually arises from residence in Canada or close contact with relatives. At all events, the simple fact, in my view, is that far less intrusive means exist to ensure such knowledge if this is indeed the goal. Training in Canadian law and institutions is an obvious answer. As Lenoir states, quote, "Another reason suggested in support of a nationality requirement is that only citizens from Commonwealth countries come with a tradition and knowledge which will fit into Ontario's system. If an individual does not possess a proper knowledge of law, this should be indicated in law school and bar admission coursework," end quote. As counsel for the respondent observes, someone who is wholly unfamiliar and incapable of dealing with the circumstances and customs of Canadian society might not be able to pass the examinations required of him by the Law Society. In respect of a lawyer's abilities, it is notable that the Law Society requires additional educational requirements of foreign-trained lawyers, whether they are Canadian citizens or not. In the present case, the respondent Andrews passed all the examinations required of Canadian-trained lawyers as well as the additional examinations required for foreign-trained lawyers. Similar logic applies with respect to the second proffered objective, that of ensuring commitment to Canadian society. On this, the Court of Appeal had to say, quote, "The second reason for the distinction, that citizenship implies a commitment to Canadian society, fares little better upon close examination. Only those citizens who are not natural-born Canadians can be said to have made a conscious choice to establish themselves here permanently and opt for full participation in the Canadian social process, including the right to vote and run for public office. While no doubt most citizens, natural-born or otherwise, are committed to Canadian society, citizenship does not ensure that this is the case. Conversely, non-citizens may be deeply committed to our country. Moreover, the requirement of commitment to our country is arguably satisfied by the oath of allegiance which lawyers are required to take. An alien may swear that oath. In any event, an alien may owe allegiance to the Crown if he is resident within this country, even if he does not take the oath of allegiance." End quote. It is to my mind clear that were these the sole objectives, the means chosen, namely the restriction of access to the profession to citizens, would quite simply be unnecessarily and also impermissibly over-inclusive. As I noted earlier, the people principally affected by this are permanent residents of Canada. Many would have applied for citizenship, and the naturalization process would ensure the necessary familiarity and commitment to Canada. That less drastic methods for achieving these objectives are available is evident from the fact that some provincial law societies simply require a declaration of an intention to become a citizen. And even this could cause serious hardship in some cases, where a person could lose his existing citizenship and incur important resulting disadvantages by acquiring Canadian citizenship, unless the bar or the courts have a discretion to exempt a person from such a requirement. In truth, I think the familiarity and commitment to Canada alleged to be sought could be achieved by restricting admission to those who are Canadian citizens or who permanently reside in Canada. If we allow people to come live in Canada, I cannot see why they should be treated differently from anyone else. Section 15 speaks of every individual. There will be exceptions, no doubt, but these require the rigorous justification provided by Section 1. It seems to me that the preceding objectives are, in this case, legitimate, but could easily be accomplished by means that would not impair a person's ability to practice law in the province to as great an extent. It is still an open question whether the right to earn a livelihood is a value constitutionally protected under the Charter, perhaps under Section 6. But whether or not such constitutional protection exists, no one would dispute that the right to earn a livelihood is an interest of fundamental importance to the individuals affected, and as such should not be lightly overridden. The third objective advanced by the Attorney General has more substance. It is that certain state activities should, for both symbolic and practical reasons, be confined to those who are full members of our political society. The Attorney General reduced his arguments regarding this objective to the following syllogism. A. Persons who are involved in the processes or structure of government, broadly defined, should be citizens. B. Lawyers are involved in the processes or structure of government. C. Lawyers, therefore, should be citizens. I do not quarrel with the first assertion as a general proposition. The Court of Appeal accepted it, noting that this rationale underlies the common requirement that legislators, voters, judges, police, and senior public servants be citizens. However, it rejected the second proposition that lawyers play a vital role in the administration of law and justice and are themselves as much a part of the government processes as are judges, legislators, and so on. It rejected the notion that the practice of law itself involved performing a state or government function. It stated, quote, "In this respect, the role of lawyers may be distinguished from that of legislators, judges, civil servants, and policemen. The practice of law is first and foremost a private profession. Some lawyers work in the courts, some do not. Those who work in the courts may represent the Crown or act against it. It is true that all lawyers are officers of the court. That term, to my mind, implies allegiance and certain responsibilities to the institution of the court. But it does not mean that lawyers are part of the process of government. It was urged before us that society accords lawyers special powers and privileges as members of the legal profession, which ally themselves with the governmental process. However, the only privilege lawyers are given is the right to charge fees for representing clients. The power to issue writs, discover documents, and subpoena witnesses is shared by every member of our society. No one suggests that a private person who exercises these powers on his own behalf is playing a role in the government of our country, nor that citizenship should be a prerequisite of so doing. The fact that lawyers do these things on behalf of others can offer no justification of the requirement that they be Canadian citizens." End quote. I agree with this statement. It is only in the most unreal sense that it can be said that a lawyer working for a private client plays a role in the administration of justice that would require him or her to be a citizen in order to be allowed to participate therein. Obviously, lawyers occupy a position of trust and responsibility in our society, but that is true of all professions, and the members of some of these, like that of chartered accountants for instance, are privy to matters of the most serious import. On a more mundane level, the essential purpose behind occupational licensing is to protect the public from unqualified practitioners. But as Lenoir points out, citizenship has not been shown to bear any correlation to one's professional or vocational competency or qualification. Like him, I see no sufficient additional dimension to the lawyer's function to assist on citizenship as a qualification for admission to this profession. It is not without significance that a requirement of citizenship has not been found to be necessary to the practice of law in either the United States or England. The doctrine of privileged communications was pressed into service, but that doctrine exists for the protection of the client. I fail to see what this has to do with the requirement of citizenship. A requirement of citizenship would be acceptable if limited to crown attorneys or lawyers directly employed by government and therefore involved in policymaking or administration, so that it could be said that the lawyer was an architect or instrumentality of government policy. But ordinary lawyers are not privy to government information any more than, say, accountants, and there are rules to restrict lawyers from obtaining confidential governmental information. I would conclude that although the governmental objectives as stated may be defensible, it is simply misplaced vis-à-vis the legal profession as a whole. However, even accepting the legitimacy and importance of the legislative objectives, the legislation exacts too high a price on persons wishing to practice law, in that it may deprive them, albeit perhaps temporarily, of the right to pursue their calling. I would therefore dismiss the appeal with costs. I would answer the first constitutional question in the affirmative and the second in the negative.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.